Hi, my name is Ian Wu. I am an estate planning attorney at Goyette, Ruano, and Thompson. We are located in Sacramento County. I've got a very important and exciting topic to share with you today. Today we'll be talking about special needs trusts, what they are, how they work, and how they'll fit into an estate plan. Remember to like and subscribe because we've got a lot more topics coming in. We're very excited to share them with you. So let's go ahead and get started. So what is a special needs trust? So a special needs trust, like many other trusts, is a relationship. It is a trustee managing assets for a beneficiary. And what this intends to do is preserve the beneficiary's eligibility for government benefits. If a beneficiary is receiving maybe an inheritance or maybe a settlement, that might be counted towards their income and thereby reduce or disqualify them from receiving benefits. Here's a common scenario. A parent or a grandparent is thinking about giving a generous gift to a child or a grandchild. Now, while the gift might be generous, they have failed to consider that that child or grandchild might be getting benefits, and giving them that gift might completely disqualify them. So one of the main questions you should ask yourself when giving a gift, especially if it's a gift generous enough based on a person's needs, is are they now getting benefits from the government? Are they looking in the future to get these benefits? Now, there's been updates in the laws about what can disqualify people from Medi-Cal. As of 2024, Medi-Cal has done away with the asset-based test, which means that participants won't necessarily get disqualified based on assets alone. Now, the law is always subject to change, and a huge important consideration for this is income still matters. Income can still disqualify a person from receiving benefits. So a lot of times a parent or someone might give a child a rental property. They're gonna want that child to continuously have an influx of rental income from that property. Well, that might disqualify that child from getting those benefits. So that's something you should be very cognizant of when giving away an income generating asset. So when we're talking about a special needs trust, we're generally thinking about two types. Now, there's something called the third-party special needs trust, and that is a special needs trust that's funded, meaning the assets come from somebody other than the beneficiary. So this applies to, let's say, when a parent, upon death, funds a special needs trust for a child beneficiary. So the other type of special needs trust that we commonly see is known as the first-party special needs trust. This trust is funded with the beneficiary's own assets. A common scenario in which this might occur could be where a person receives a large inheritance and doesn't want those assets to disqualify them from benefits. So they fund their own special needs trust with it to keep it separate so that it doesn't disqualify them. Another scenario might be where somebody's injured in an accident, is now receiving government benefits, but gets a large settlement that might affect their eligibility. So they fund that into a first-party special needs trust. So one of the main differences between a first-party and a third-party special needs trust that I want to highlight is for first-party special needs trusts. Remember, these are the ones that are funded with the beneficiary's own assets, needs to include something called the Medi-Cal payback provision, meaning if that beneficiary dies, before that first-party special needs trust goes to anybody else, Medi-Cal gets paid back first. Now, that doesn't need to be required by the third-party special needs trust. Another thing to think about is who's going to be in charge of the special needs trust. You want to make sure that it's someone you trust, but not just on a personal level, someone that you trust on a responsibility level to follow the rules. If this person starts breaking the rules of a special needs trust, common rules could be giving cash to a beneficiary. It could start counting as income and disqualify them, just thwarting the whole purpose of the special needs trust. You might consider maybe looking into getting a professional fiduciary, maybe a trust officer, someone that makes sure that income taxes will be filed in a timely manner on behalf of the trust as well. So leaving a gift to a loved one is a thoughtful thing to do, especially if that loved one has certain needs, maybe there's a condition affecting them that you are trying to account for the future, but you should always be careful when doing so. I always recommend contacting an estate planning attorney who's dealt with special needs trust before, someone who's updated on eligibility law and special needs trust planning. We're here at Goyette, Ruano, Thompson. We serve many clients in California, northern and southern. We deal with special needs trust planning here. Feel free to call us for a consultation. Our information's in the website. Hit the link below, like and subscribe. Many more videos to come, and looking forward to seeing you next time. As always, my name's Ian Wu with Goyette, Ruano, and Thompson. Stay safe, stay protected, and you can do both by staying prepared.